Warm welcome. You're with the big story right here on Headlines today, emanating outside the Supreme Court. Two big news points we can break for our viewers at this point of time. Exactly 10 minutes ago, the list of 628 names was presented before the Supreme Court. Three sets were given to the honorable bench. That's one piece of news that we can break. Secondly, massive observations coming in from the Supreme Court, hugely embarrassing for the government. The Supreme Court has asked nodal agencies to be included in the ambit of investigation, and I'd like to cut across for this news break. Ashish Merishi is with me at this point of time. Ashish, quickly take us through the news break, and why is it so embarrassing for this government?
Very embarrassing for the government, not only this government but for the past government as well. You know, this list came to in the possession of Indian authorities around 3.5-4 years back, Preeti. Now surprisingly, in that 3.5-4 years back, when they got this list in their hand, they should have given it to the agency, which is the nodal agency, to investigate. You know, the big question, it is common sense. The biggest question would be how this money landed abroad. Somebody should know. Was it a hawala transaction? Was it proceeds of crime? Or was that bribe money taken abroad? These things needs to be investigated. Or there are people who are holding accounts on somebody's behalf. These are areas that needs to be investigated. There is a foreign taxation department in income tax department as well, but then they are going to investigate only the tax aspect. Now the income tax department works under the income tax act, and there are certain limitations, but then there are certain areas which is a nodal agency called Enforcement Directorate. It works under the Prevention of Money Laundering Act. It works under the Foreign Exchange Management Act, and then there is CBI, which works under the Prevention of Corruption Act. We have to find out how that money landed abroad, and that is what precisely we were discussing in the morning, and that is what the Supreme Court has asked to do. Now this is very, very embarrassing for the government, for the reason that the government should have handed over this list to Enforcement Directorate and CBI long back, but now surprisingly they said that it is because of double taxation avoidance agreement that they cannot share the list with any other agency. It is very, very surprising. How can you have a agreement with different countries where you say that this list can only be used only for tax purposes? This is very, very surprising, and it has brought massive embarrassment to the government.
Ashish, stay on with us. Let's get a quick comment in by Bhavna Doshi. She's a tax expert. She's in the studio with us. She's taking us through the legalities, breaking it down in layman terms. Miss Doshi, if you can hear me, ma'am.
Yes.
Quickly, earlier on we were talking about the fact how the ED is at loggerheads with the Tax Authority of India, the Income Tax Authority of India, wanting the list, and the Income Tax Authority of India refusing to share it. And now the Supreme Court doing precisely that.
Yeah, so basically what Supreme Court has said is that this information be made available to SIT, and then SIT will in turn pass it on or use services of ED or whatever is required. Now, as per the information exchange that has taken place, and that is amended also as part of the double tax avoidance treaty with Switzerland, what it says is that the information that is made available under the treaty can be used only for the tax purposes. It can be used for any other purpose if that is legal to do so in both the countries, and if the competent authority of the country which has supplied the information permits, allows. Now that really cannot apply to this situation, because currently the information that is made available is not in terms of the treaty. This treaty is signed in 2010, that is subsequent to the date on which the information was made available. So the issue is whether this information can be used for any other purpose. It's a big question mark in terms of the treaty. But then one of the arguments could
be... And yes, and that was what even Ashish Merishi, my colleague, was talking about, and I'd like to cut across back to Ashish. Ashish, pertinent points made by a tax expert in the studio, Ms. Bhavna Doshi, where she also goes on to state, because that there will be a fair bit of confusion where it comes down to the treaties that India has signed with other countries, if this list is shared with other nodal agencies like the ED and FEMA.
Well, in fact, Preeti, if you see, this is the list of 2006, and that is why the amendment to the Income Tax Act was made, and you can open cases now not only up to 6 years but to 16 years. But again, you have to find out how that money landed abroad. and that is why there is agency called Enforcement Directorate and CBI that needs to investigate the matter. But again, whatever the perspective is, especially the double taxation avoidance agreement, this does not apply especially to this list. This was a stolen list given by French authorities, and the double taxation avoidance agreement was signed in 2010. The stolen data, which has been authenticated by the Swiss authorities, after the investigation of Indian authorities, how did double taxation avoidance agreement apply to that? That is a big question mark again. Then again, why should only the tax area should be investigated? Why should we bother only about the tax? We should also know how that money landed abroad. And that is why the Supreme Court has directed the Enforcement Directorate and CBI to investigate into this matter. Now 627 names, 1/3 are NRIs. They are legitimately allowed to open those bank accounts. But then again, 2/3 needs to be investigated. What happens to that investigation? I remember I have seen that letter with my own eyes, where the Enforcement Directorate in the year 2012 had written to the Central Board of Direct Taxes, and the Central Board of Direct Taxes had refused to the Enforcement Directorate, saying that it is under the double taxation avoidance agreement and only tax issues can be covered, thus we cannot share it with you. Now it is very surprising. It is the two arms of the Finance Ministry, where one is investigating and other is not being allowed to investigate. This is very, very surprising, and it has certainly brought embarrassment not only to this government but to the past government as well.
You know, Ashish, there's the latest that is coming in right now from the Supreme Court. The SIT has been told to file a report by the end of November. Do you have more details on this news break? Can you hear me, Ashish?
Constituted by the Supreme Court, they said they have trust in SIT and has asked SIT to share the data with ED and CBI. Thus, they will have to submit the status report by the end of November. This is the directive by the Supreme Court. So interesting. This is very, very interesting observation by the Supreme Court, and thus, you know, it has left the government very embarrassed. They should have shared this data earlier with the other investigative agencies like ED and CBI. So very, very surprising.
Okay.
All right, a whole host of political reactions coming in, and with me in the studio is Executive Editor Javed Ansari. I'm also joined by our tax expert at this point in time, Ms. Bhavna Doshi. I'd like to come to you, Ms. Bhavna, first. What do you make of the current developments that are taking place, given the fact that there are 627 accounts that have been declared in that sealed envelope, but obviously not all of them are illegal, and definitely prosecution cannot be initiated against all of them?
Yes, so as government and as we heard Mr. Rohatgi mentioning, these are in different stages. Now some are of NRIs, where there is no illegality, and some which are of resident Indians, where there could be illegalities, and those are being investigated. Also on the aspect that whether there could be additional investigation looking into the other aspect like prevention of money laundering or violation of FERA of those days, because this is now for 16 years, as Mr. Rohatgi mentioned. So 2015 is the date where they are saying would be the last date by which they would like to complete the investigation and complete the assessments as well. Now that means prior to 1998, the investigation cannot take place so far as income tax is concerned. Now in 1998, FERA was repealed, and therefore no further action can be taken under FERA today.
Right.
And remember, there's a difference between FERA and FEMA. FERA, one could be prosecuted. In FEMA, that is the current law, there can be no prosecution, but there could be penalties, and penalties could be as heavy as even 3 times of the amount involved.
Right.
So penalties are pretty high, and those investigations can take place.
Well, absolutely. Impending investigations will in fact throw light on what really the future course of action in this black money matter is going to be. We have our reporters fanned out across the national capital, getting you all the latest political reactions and of course the inside track from the Supreme Court.